The morning I found the bright orange citation taped to my truck window. I was still half asleep with my coffee mug steaming in the frigid February air. The paper fluttered against the frost-covered glass like some kind of aggressive bird, and I could already feel my blood pressure rising before I even read what it said. I yanked it off, leaving a sticky residue behind, and scanned the typed notice that informed me in very formal language that I was in violation of Section 7.3.2 of the Riverside Meadows Homeowners Association bylaws regarding commercial vehicle parking. The fine, $500, due within 30 days. I stood there in my driveway in Lakewood, Colorado, staring at my perfectly legal snow plow truck that I used for my small landscaping and snow removal business. The truck was barely 6 years old, well maintained, and parked exactly where it had been parked for the last 3 years since I moved into this neighborhood. Nothing had changed. The vehicle had my company logo on the side, sure, but it was not some massive commercial rig. It was a Ford F-350 with a plow attachment, the kind of truck that half the guys in Colorado owned whether they ran a business or not. My name is Quincy Zimmerman, and I had worked hard to build my business from the ground up. After leaving my corporate job in Denver 5 years ago, I started doing lawn care and snow removal for residential properties. The work was honest, the money was decent, and I was my own boss. I had purchased this house in Riverside Meadows specifically because it had a long driveway with plenty of space for my equipment. When I bought the place, I had even asked my real estate agent about parking restrictions, and she assured me there would not be any issues. I crumpled the citation in my fist and stormed back into the house, tracking snow across the mudroom floor. My dog, a golden retriever named Buck, looked up from his bed with concern. I grabbed my phone and immediately started searching through my email archives for the original property documents. There had to be something in there about parking. I was not the kind of person who just accepted fines without understanding why they were being issued. After 20 minutes of digging through files, I found the property deed and the HOA covenant documents. I started reading through the dense legal language, most of which made my eyes glaze over. But then, I found something interesting in the easement section. My driveway had a specific easement notation that dated back to when the neighborhood was first developed in 1998. The easement language explicitly stated that the driveway on Lot 47, which was my property, maintained commercial vehicle access rights due to its original designation as a service access point for the development during construction. I read the paragraph 3 times to make sure I was understanding it correctly. According to this document, my driveway was legally allowed to accommodate commercial vehicles because it had been used as a construction access point when the neighborhood was built. The easement had never been removed or modified. This was legally binding language that predated any HOA bylaws about commercial vehicles. I felt a surge of satisfaction mixed with irritation. The HOA had just fined me $500 for something that was explicitly allowed according to my property's easement rights. I immediately took photos of the relevant pages and started composing an email to the HOA board. But then, I stopped myself. Something told me this was going to require more than just a polite email with attachments. I needed to understand exactly who had issued this citation and why they had not bothered to check the property records first. The next morning, I drove to the Riverside Meadows HOA office, which was located in a small building near the neighborhood entrance. The office was only open 3 days a week, and I had to rearrange my morning schedule to get there during their limited hours. When I walked in, A woman in her mid-50s with perfectly styled blonde hair looked up from behind a desk. Her name tag read Brenda Fairchild, HOA President. She had the kind of expression that suggested she had never been told no in her entire life. "Can I help you?" she asked, her voice dripping with the kind of false sweetness that immediately put me on edge. "Yes, I am Quincy Zimmerman from 847 Riverside Drive. I received this citation yesterday about my truck." I placed the crumpled orange paper on her desk. Brenda picked it up with 2 fingers as if it were contaminated and smoothed it out. "Oh yes, the commercial vehicle. We have been receiving complaints from your neighbors about that eyesore parked in your driveway." Eyesore? I felt my jaw tighten. It is a work truck. And I have an easement that allows commercial vehicles on my property. She looked at me with a patronizing smile. "Mr. Zimmerman, all residents are subject to the HOA bylaws, which clearly state that commercial vehicles are not permitted to be parked in plain view. It is in Section 7.3.2. Perhaps you should review your covenant documents more carefully." "I have reviewed them," I said, pulling out my phone and opening the photos I had taken. "My property has a specific easement that allows commercial vehicle access. It is right here in the original deed." I held out my phone, but Brenda barely glanced at it. "Easements have nothing to do with HOA bylaws, Mr. Zimmerman. The bylaws supersede any previous property designations. You will need to remove that vehicle from view or pay the fine. If you continue to violate this rule, the fines will increase to $100 per day." I stared at her, stunned by her complete dismissal of documented legal rights. "That is not how easements work. They are legally binding property rights that cannot be overridden by HOA bylaws." "I disagree," Brenda said flatly. "And unless you want those fines to pile up, I suggest you move your truck into a garage or off the property entirely. This is not up for debate." I took a deep breath, trying to keep my temper in check. "I would like to present this information to the full HOA board at the next meeting." The next board meeting is not until March 15th, 3 weeks from now. The fine is due in 30 days regardless of whether you attend the meeting or not. She picked up a pen and returned her attention to whatever paperwork she had been working on before I arrived, clearly signaling that our conversation was over. I left the office feeling a mixture of anger and disbelief. Brenda Fairchild had not even looked at the easement documentation. She had simply decided that the HOA rules were absolute, regardless of what the actual property law said. This was going to be more complicated than I had anticipated. Over the next few days, I did my research. I called a real estate attorney named Marcus Chen, who had done some work for me when I purchased the house. I explained the situation and sent him copies of both the HOA citation and the easement documentation. "This is pretty straightforward," Marcus said during our phone call. "Easements are property rights that run with the land. They cannot be overridden by HOA bylaws. The HOA can create rules, but those rules cannot violate existing legal property rights. Your easement explicitly allows commercial vehicle access, which means the HOA has no authority to fine you for parking your work truck there." "So what do I do?" I asked. "First, send a formal response to the HOA in writing, citing the easement and making it clear that you are not paying the fine. Reference the specific legal language and include copies of the easement documentation. Make sure you send it certified mail so you have proof of delivery. Then, if they continue to pursue the fine, you will need to either go to the board meeting and fight it, or potentially take legal action if they refuse to back down." I followed Marcus's advice and drafted a formal letter that afternoon. I kept it professional but firm, explaining that my property's easement granted explicit rights for commercial vehicle parking and that the HOA's citation was therefore invalid. I attached copies of the relevant deed pages and the easement language. I sent it certified mail that same day. 2 weeks passed without any response from the HOA. I continued parking my truck in my driveway as usual and went about my business. The snow that February was relentless, and I was working 12-hour days plowing driveways and parking lots all over Lakewood and the surrounding areas. My truck was constantly covered in road salt and grime, and I barely had time to think about the HOA situation. Then, on a Friday afternoon, I came home to find not one but 3 new citations taped to my truck. Each one was for $100 per day, claiming that I had continued to violate the commercial vehicle parking rules. The total fines now amounted to $800, in addition to the original $500 fine. I ripped the citations off my windshield and immediately called Marcus Chen. "They are escalating the fines," I told him. "They did not even respond to my letter. They just started charging me $100 a day." Marcus sighed. "That is aggressive but not surprising. Some HOAs get really dug in on these kinds of disputes. You need to attend that board meeting and make your case in person. Bring all your documentation, and I will prepare a brief legal summary that you can present to them. If they still refuse to drop the fines after that, you will have grounds for a lawsuit, and honestly, you would win." "I do not want to sue anyone," I said, frustrated. "I just want to park my truck in my own driveway without being harassed." "I understand, but you need to be prepared for that possibility. HOAs have a lot of power, and sometimes the only way to fight back is through the legal system." The board meeting was scheduled for March 15th at 7 in the evening. I marked it on my calendar and spent the next week preparing my presentation. Marcus sent me a 2-page legal brief that clearly outlined the easement law and why the HOA's fines were invalid. I printed multiple copies and organized all my documentation into a folder. The night of the meeting, I arrived at the community center where the board meetings were held. The room was set up with a long table at the front where 5 board members sat, including Brenda Fairchild in the center. About 20 other residents were scattered throughout the folding chairs, most of them looking bored or checking their phones. Brenda called the meeting to order and worked through the standard agenda items: minutes from the last meeting, financial reports, updates on landscaping contracts. I sat through it all, waiting for the open forum section where residents could bring up issues. Finally, after nearly an hour, Brenda announced, "We will now open the floor to resident comments. Please keep your remarks to 3 minutes or less." I stood up and walked to the front of the room, my folder in hand. "My name is Quincy Zimmerman, and I am here to address the citations I have received regarding my work truck. I have been fined a total of $1,300 for parking a commercial vehicle in my driveway. However, my property has a specific easement that allows commercial vehicle access." I opened my folder and pulled out the copies of the easement documentation, walking them over to the board table. This easement was established when the neighborhood was developed in 1998. It is a legal property right that runs with the land, which means it cannot be overridden by HOA bylaws. I also have a legal brief from my attorney that explains why these fines are invalid. Brenda took the documents without looking at them and set them aside. "Mr. Zimmerman, we have already discussed this. The HOA bylaws are clear. Commercial vehicles are not permitted. But the easement supersedes the bylaws," I said, keeping my voice steady. "This is not a matter of opinion, this is property law." One of the other board members, a man in his 60s named Gerald, spoke up. "We cannot just allow everyone to park whatever they want in their driveways. It brings down property values. Next thing you know, people will have RVs and boats sitting out front. This is not about RVs or boats, I said. This is about a documented legal right that is specific to my property. I am not asking you to change the rules for everyone. I am asking you to recognize that my property has a special easement that was established decades ago. Brenda shook her head. I am sorry, Mr. Zimmerman, but we are not going to make an exception. If we do it for you, then everyone will want special treatment. The fines stand, and they will continue to accumulate until you comply with the bylaws. I felt my frustration boiling over. This is not an exception. This is a legal right. You cannot fine me for exercising a legal right. We can, and we are, Brenda said coldly. If you do not like it, you are welcome to take it up with a lawyer, but I can assure you that fighting the HOA is an expensive and time-consuming process. Most people find it easier to just comply. I looked around the table at the other board members, hoping someone would speak up in my defense, but they all avoided my gaze. Fine, I said. I will see you in court. I walked out of the meeting, my hands shaking with anger. The entire process had been a sham. They had not even looked at the documentation I provided. Brenda Fairchild had made up her mind before I even walked in the door, and the rest of the board was too spineless to challenge her. The next morning, I called Marcus Chen and told him what had happened. They would not even look at the easement documents, I said. They just dismissed everything and said the fines would keep piling up. Okay, Marcus said calmly, then we need to file a lawsuit. We will seek an injunction to stop the fines and a declaratory judgment that confirms your easement rights. I will also include a claim for attorney fees, because HOAs that act this unreasonably often end up having to pay for the legal costs when they lose. How much is this going to cost me? I asked. I will do it on a contingency basis with a reduced retainer, Marcus said. Given how strong your case is, I am confident we will win, and the HOA will end up covering the costs. You will need to put down $1,500 to get started, and then we will handle the rest. It was a lot of money, especially with the business being in its slower spring season, but I did not see any other choice. Let's do it, I said. Marcus filed the lawsuit the following week. The legal complaint outlined the easement rights, detailed the HOA's citations and fines, and argued that the HOA had violated my property rights by refusing to recognize the legally binding easement. We requested an immediate injunction to stop the accumulation of fines, and a court order declaring that my driveway easement allowed commercial vehicle parking. The HOA was served with the lawsuit on March 25th. I did not hear anything from them directly, but I did notice that no new citations appeared on my truck. The daily fines seemed to have stopped, at least temporarily. 2 weeks later, Marcus called me with an update. The HOA has hired an attorney and they filed a response. They are arguing that the easement language is ambiguous and that it only applied during the construction phase of the neighborhood. They claim it expired once the development was completed. That is ridiculous, I said. The easement does not say anything about expiring. It is a permanent property right. I agree, and that is what we will argue, but this means the case is going to take longer than I initially thought. The judge has scheduled a hearing for May 20th to address the injunction request. In the meantime, I recommend you document everything. Take photos of your truck, keep records of any new citations, and note any interactions with the HOA or your neighbors. I followed Marcus's advice and started keeping detailed records. I took daily photos of my truck parked in the driveway and made notes of the times and dates. I also started noticing increased hostility from some of my neighbors. A few people who had always been friendly suddenly stopped waving when I drove by. One neighbor, an older woman named Patricia who lived 3 houses down, actually yelled at me one morning as I was loading equipment into my truck. "You are ruining this neighborhood," she shouted from her front porch. "Nobody wants to look at your disgusting truck every day." I was tempted to yell back, but I knew it would not help my case. Instead, I just nodded and continued loading my equipment. It was becoming clear that Brenda Fairchild had been spreading her version of the story throughout the neighborhood, painting me as some kind of troublemaker who refused to follow the rules. In mid-April, I received a letter from the HOA's attorney. It was a formal demand to either remove the commercial vehicle or pay the accumulated fines, which now totaled over $4,500. The letter also threatened to place a lien on my property if I did not comply within 10 days. I immediately forwarded the letter to Marcus. He called me back within an hour. "They cannot place a lien on your property for fines that are being disputed in court," he said. "This is an intimidation tactic. Do not respond to this letter. Let me handle all communication with their attorney." The stress was starting to take a toll. I was losing sleep, worrying about the lawsuit and the mounting legal costs. My business was doing fine, but the distraction was affecting my focus. I made a few scheduling mistakes and had to deal with some unhappy customers. Buck seemed to sense my anxiety and followed me around the house more than usual, resting his head on my knee whenever I sat down. Finally, May 20th arrived, and I had my day in court. The hearing was held at the Jefferson County Courthouse in Golden, Colorado. I met Marcus outside the courtroom, and he went over what to expect. "The judge is going to hear arguments from both sides about the injunction request," Marcus explained. "We need to convince him that you have a strong likelihood of success on the merits of the case, and that you will suffer irreparable harm if the fines continue to accumulate. The HOA is going to argue that the easement is expired or invalid, and that you should have to follow the same rules as everyone else." We entered the courtroom, and I saw Brenda Fairchild sitting on the other side with a lawyer in an expensive-looking suit. She glared at me as I took my seat. The judge, an older man named Judge Raymond Porter, entered and everyone stood. The hearing began with Marcus presenting our case. He walked the judge through the easement documentation, explaining how the language clearly established permanent commercial vehicle access rights for my property. He showed the judge copies of the HOA citations and the accumulating fines, arguing that allowing them to continue would cause significant financial harm while the case was being litigated. The HOA's attorney, a woman named Sandra Morrison, argued that the easement was only intended for construction purposes and that it had no relevance once the neighborhood was built. She claimed that allowing commercial vehicles to park in residential driveways would harm property values, and that the HOA had a legitimate interest in enforcing its bylaws. Judge Porter listened carefully to both sides, occasionally asking questions. At one point, he asked Sandra Morrison directly, "Can you point to any language in the easement document that indicates it was temporary or limited to construction purposes?" Sandra hesitated. "Your Honor, the context of the easement suggests it was intended for construction access. There is no reason a residential property would need permanent commercial vehicle rights. Except that my client runs a business and needs to park his work vehicle," Marcus interjected. "The easement does not specify that it is temporary. Under property law, easements are presumed to be permanent unless explicitly stated otherwise." Judge Porter nodded and made some notes. After both attorneys finished their arguments, he leaned back in his chair and looked at the documents in front of him. "I am going to grant the injunction," he said finally. "Based on the preliminary evidence, it appears that Mr. Zimmerman has a strong case that this easement grants him the right to park commercial vehicles on his property. The HOA is enjoined from assessing any additional fines related to this issue until the case is resolved. I am scheduling a full trial for August 12th to address the merits of the case." I felt a wave of relief wash over me. It was not a complete victory, but at least the fines would stop piling up. Brenda Fairchild looked furious as she stood up and walked out of the courtroom without looking in my direction. Outside the courthouse, Marcus shook my hand. "That went well," he said. "The judge clearly sees that you have a valid easement. Now we just need to prepare for trial and make sure we can prove that the easement is permanent and enforceable." Over the next few months, Marcus worked on building our case. He hired a real estate expert to provide testimony about easement law and obtained historical records from the county showing how the neighborhood was developed. We also discovered that there were 2 other properties in Riverside Meadows that had similar easements, though neither of those homeowners had been cited for parking violations. During this time, life in the neighborhood became increasingly uncomfortable. Brenda Fairchild seemed to have made it her personal mission to make my life difficult. She sent me multiple letters about other alleged violations, minor things like my trash cans being visible from the street for more than 12 hours after pickup, or my lawn being a 1/4 inch longer than the maximum allowed height. Each letter threatened fines if I did not immediately comply. I documented everything and forwarded it all to Marcus. He assured me that this pattern of harassment would actually help our case, showing that the HOA was targeting me unfairly. In late June, something unexpected happened. I received a knock on my door one evening, and when I answered, I found a man in his 40s who introduced himself as Kevin Morris. He lived 2 streets over and said he had heard about my lawsuit with the HOA. "I just wanted to let you know that I support what you are doing," Kevin said. "Brenda Fairchild has been a nightmare for a lot of people in this neighborhood. She runs the HOA like her own personal fiefdom. A few years ago, she fined my wife and me $2,000 because we painted our front door the wrong shade of red. We ended up just paying the fine because we could not afford to fight it, but I always regretted not standing up to her." "I appreciate you telling me that," I said. "It has been pretty stressful dealing with all of this." "I bet," Kevin said. "Look, there are a lot of people in this neighborhood who are tired of Brenda's bullying. If you need witnesses or people to testify about her behavior, I think you would find plenty of volunteers." That conversation gave me hope. I realized I was not alone in this fight. Brenda had been abusing her power for years, and people were ready for someone to finally push back. Marcus thought Kevin's offer was valuable. "If we can show a pattern of the HOA targeting residents unfairly, it strengthens your case. It demonstrates that this is not just about enforcing reasonable rules, but about personal vendettas and abuse of authority." We reached out to Kevin and several other residents who had been on the receiving end of Brenda's enforcement actions. 3 people agreed to provide written statements describing their experiences with the HOA. One woman named Jennifer had been fined for having a vegetable garden in her backyard that was supposedly visible from the street. Another resident, Tom, had been cited for parking his classic car in his driveway because Brenda claimed it was an inoperable vehicle, even though it ran perfectly fine. As the trial date approached, Marcus felt increasingly confident about our case. "The more I dig into this, the clearer it becomes that the HOA has been operating outside its authority," he told me during one of our preparation meetings. "Your easement case is solid, but we also have evidence of a broader pattern of misconduct That is going to be important. The trial began on August 12th at 9 in the morning. The courtroom was larger than the one used for the injunction hearing, and there were more people present. I recognized several of my neighbors, including Kevin Morris and the others who had provided statements. Brenda Fairchild was there with Sandra Morrison and 2 other board members. The trial lasted 3 days. Marcus presented our case methodically, starting with the easement documentation and the property records. He called a real estate expert who testified that the easement language was clear and unambiguous, granting permanent commercial vehicle access rights. The expert also explained that such easements were common in developing neighborhoods and were intended to provide flexibility for future property use. Sandra Morrison tried to argue that the easement was outdated and that the HOA bylaws should take precedence, but the expert disagreed. HOA bylaws cannot override recorded property easements, the expert testified. The easement is a superior legal right that was established when the property was created. The HOA was formed later and is bound by existing property rights. Marcus also called several of the neighbors who had been harassed by the HOA. Kevin Morris testified about his front door fine, explaining how Brenda had measured the color with some kind of color wheel device and determined it was 2 shades too bright. Jennifer described how Brenda had demanded she remove her vegetable garden, even though it was completely in her backyard and barely visible from the street. Tom gave particularly compelling testimony about his classic car. He explained that Brenda had issued a citation claiming the car was inoperable, but when he showed her that it ran perfectly, she changed the violation to say that it was a commercial vehicle because he sometimes drove it to car shows where he sold merchandise. It was like she was just making up reasons to fine me, Tom said. She wanted that car gone, and she did not care what the actual rules said. Sandra Morrison tried to defend the HOA's actions, arguing that the board had a responsibility to maintain property values and aesthetic standards. She called Brenda Fairchild to testify, and Brenda spent nearly an hour on the stand defending every citation and fine she had ever issued. "We have clear rules in this neighborhood," Brenda said. "If people do not like the rules, they should not live here. It is as simple as that." During cross-examination, Marcus pressed Brenda about why she had never investigated the easement on my property before issuing the citations. "Did you review the property records before fining Mr. Zimmerman?" he asked. "I reviewed the HOA bylaws," Brenda said defensively. "That is what I am required to enforce. But did you check to see if his property had any special designations or easements that might affect the bylaws?" "No, I did not think that was necessary. The bylaws apply to everyone. Even if someone has a legal property right that conflicts with the bylaws," Brenda hesitated. "The bylaws are the rules we all agreed to follow." "That is not what I asked," Marcus said firmly. "Mr. Zimmerman has an easement that explicitly allows commercial vehicles on his property. You issued fines without ever checking whether such an easement existed. Is that correct?" "I suppose so," Brenda admitted reluctantly. Marcus also questioned Brenda about the pattern of fines against me after the lawsuit was filed. "After Mr. Zimmerman took legal action, you issued multiple additional citations against him for various minor violations. Is that correct?" "Those were legitimate violations," Brenda said. "Did you inspect Mr. Zimmerman's property more frequently than other properties in the neighborhood?" Brenda's face flushed. "I inspect all properties regularly." Marcus pulled out a document. "According to the HOA's own records, you issued citations to Mr. Zimmerman on 8 separate occasions between March and July of this year. During that same period, You issued a total of 3 citations to all other residents combined. Does that seem proportionate to you? Mr. Zimmerman was violating multiple rules, Brenda said weakly. The testimony was damaging. It was clear that Brenda had targeted me after I challenged her authority, and the pattern of citations showed personal animus rather than objective enforcement of the rules. On the third day of trial, both sides gave their closing arguments. Marcus summarized the evidence, emphasizing the clear language of the easement and the HOA's failure to respect established property rights. He also highlighted the pattern of harassment and abuse of authority that had characterized Brenda's leadership. This case is about more than just one truck parked in one driveway, Marcus told the judge. It is about whether HOAs can ignore established property law and harass homeowners who dare to challenge them. Mr. Zimmerman has a legal right to park his commercial vehicle on his property. The HOA has tried to bully him into giving up that right through escalating fines and retaliatory citations. We ask this court to declare that the easement is valid and enforceable, to void all fines that have been assessed, and to award attorney fees for the costs my client has incurred defending his basic property rights. Sandra Morrison's closing argument focused on the importance of HOA rules and the need to maintain neighborhood standards. She argued that allowing commercial vehicles would set a bad precedent, and that the court should defer to the HOA's judgment about what was best for the community. Judge Porter took the case under advisement and said he would issue a written ruling within 2 weeks. Those 2 weeks were agonizing. I tried to focus on work, but my mind kept drifting back to the trial. Had we done enough? Would the judge see through Brenda's arguments? What would happen if we lost? Finally, on August 28th, Marcus called me. We won, he said, and I could hear the satisfaction in his voice. The judge issued a comprehensive ruling. He found that your easement is valid and enforceable, that the HOA had no authority to fine you for parking your truck, and that all fines assessed are void. He also awarded us attorney fees, which means the HOA has to pay for your legal costs. I felt a surge of relief so powerful that I had to sit down. All of it, I asked. Everything? Everything, Marcus confirmed. The judge was pretty critical of the HOA's conduct. He noted that they failed to do basic due diligence before issuing fines, and that the pattern of citations after you filed the lawsuit suggested retaliatory motives. He ordered the HOA to cease any enforcement actions related to your vehicle and to pay $6,200 in attorney fees. I could hardly believe it. After months of stress and uncertainty, I had finally won. My driveway easement was recognized, the fines were gone, and I would not have to pay the legal costs. The judge's written ruling was 12 pages long and went into considerable detail about easement law and HOA authority. In one particularly pointed section, Judge Porter wrote, "While homeowners associations serve an important function in maintaining community standards, they are not above the law. They cannot override established property rights through bylaws, and they cannot use their enforcement powers to harass homeowners who challenge their decisions. The evidence in this case shows a troubling pattern of behavior by the HOA that goes beyond reasonable enforcement of legitimate rules." Within days of the ruling, I received a formal letter from the HOA acknowledging the judgment and confirming that all fines had been voided. The letter was signed by Gerald, the board member who had spoken up during the board meeting, not by Brenda Fairchild. I found out why a week later when Kevin Morris stopped by my house with news. Brenda resigned from the HOA board, he told me with a grin. Apparently, the other board members were furious about the lawsuit and the money it cost the association. They forced her out. Really? I was surprised. I had assumed Brenda would cling to her position no matter what. Really, Kevin confirmed. And there is more. A bunch of residents have filed complaints with the remaining board members about how Brenda ran things. People are demanding refunds for fines they paid over the years. It is turning into a whole thing. That whole thing turned into a full-scale revolt against the old HOA leadership. Over the next month, more than 40 residents submitted formal complaints about past fines and enforcement actions. Many of the complaints involved situations similar to mine, where Brenda had issued citations without proper justification, or had targeted specific homeowners she did not like. The remaining board members, realizing they were facing potential legal liability, hired an independent auditor to review all fines and citations issued over the previous 5 years. The audit revealed numerous problems. Many fines had been issued without proper notice or opportunity for residents to respond. Some violations had never actually been documented with photos or evidence. And in several cases, Brenda had issued fines for violations that did not actually exist in the bylaws. The audit report was released at a special HOA meeting in October. I attended out of curiosity, and the community center was packed with residents. The audit revealed that Brenda had collected over $87,000 in fines during her 5-year tenure as HOA president. Of that amount, nearly $32,000 were for violations that were either improperly documented or not actually violations at all. The board voted unanimously to refund any fines that the audit had identified as improper. They also voted to amend the HOA bylaws to add due process protections for residents facing citations, including mandatory written notice, the right to respond before fines are assessed, and an independent appeals process. The changes were significant and long overdue. Several residents thanked me publicly for fighting back against Brenda's authoritarianism. One woman, close to tears, told me that she had paid $1,500 in fines a few years ago for landscaping violations that she now realized were completely fabricated. But the story did not end there. In November, something happened that I did not expect. A resident named Diana came forward with allegations that Brenda had embezzled money from the HOA. Diana had been helping with the financial audit and noticed irregularities in the accounting records. Specifically, there were several cash payments for services that had no corresponding invoices or documentation. The board immediately launched a more detailed investigation, this time focusing specifically on financial controls and cash handling. They brought in a forensic accountant who spent 3 weeks reviewing every transaction from the past 5 years. The forensic accountant's report was damning. Brenda had created fake invoices for landscaping and maintenance services, approved the payments herself, and pocketed the cash. The total amount of embezzled funds was just over $14,000. Additionally, she had used the HOA credit card for personal expenses, including dinners, shopping, and even a weekend trip to Las Vegas that she claimed was for a property management conference that never existed. The board had no choice but to report the findings to the police. In early December, 2 detectives from the Lakewood Police Department came to Brenda's house and arrested her on charges of embezzlement and theft. The arrest made the local news, and I watched the story on television with a mixture of satisfaction and sadness. Satisfaction that Brenda was finally being held accountable, but sadness that it had gone so far. Brenda was released on bail and hired a criminal defense attorney. Her attorney tried to negotiate a plea deal, but the district attorney was not interested in being lenient. The evidence was overwhelming, and the prosecution had bank records showing that Brenda had deposited HOA checks into her personal account. The criminal trial took place in March of the following year. I was called as a witness, not about the embezzlement but to provide context about Brenda's behavior as HOA president. I testified about the citations, the fines, and the pattern of harassment. The prosecution used my case as an example of how Brenda had abused her authority across the board, not just financially, but in every aspect of her role. The jury deliberated for less than 4 hours before returning a guilty verdict on all counts. Brenda was convicted of embezzlement, theft, and fraud. At the sentencing hearing in April, the judge sentenced her to 3 years in prison and ordered her to pay full restitution to the HOA, plus fines and court costs. As I sat in the courtroom listening to the sentence, I thought about how this entire saga had started with a simple citation on my truck windshield. I had never wanted any of this. I just wanted to park my work vehicle in my own driveway without being hassled. But by standing up for my rights, I had inadvertently exposed years of corruption and abuse. After the sentencing, several of my neighbors approached me in the courthouse hallway. Kevin Morris shook my hand firmly. "You did the right thing," he said. "If you had not fought back, Brenda would still be running that HOA like a dictator and stealing from all of us." Jennifer, the woman with the vegetable garden, gave me a hug. "Thank you for having the courage to stand up to her," she said. "A lot of us were too scared or too tired to fight." Life in Riverside Meadows improved dramatically after Brenda's removal. The new HOA board, which included Kevin Morris and 2 other reasonable people, adopted a much more balanced approach to enforcement. They focused on actual problems that affected the neighborhood, like maintaining common areas and addressing safety issues, rather than nitpicking minor aesthetic complaints. The new board also formally acknowledged my driveway easement and added a note to the property records so that no future board could try to challenge it. They apologized for the stress and expense I had endured and thanked me for helping to expose the corruption. My business continued to grow, and I eventually bought a second truck and hired 2 employees. Both trucks park in my driveway every night, and no one says a word about it. In fact, several neighbors have hired me for snow removal and landscaping services, appreciating the convenience of having a reliable local contractor. I still see some of the people who sided with Brenda during the dispute, like Patricia, who had yelled at me about my truck. She avoids making eye contact when I drive by, and I do not bother trying to engage. Some relationships were damaged beyond repair, and that is okay. I learned through this experience that standing up for what is right sometimes means accepting that not everyone will like you. Buck, my golden retriever, still greets me every evening when I come home from work, completely unconcerned with HOA drama or property easements. He just wants his dinner and a belly rub, which is a good reminder that life is about more than legal battles and neighborhood politics. The following summer, the neighborhood held its annual 4th of July block party. For the first time in years, the atmosphere was relaxed and friendly. People were not worried about getting citations for having their chairs too close to the street or their decorations being the wrong color. The new board had authorized the use of HOA funds to hire a food truck and rent a bounce house for the kids. It was the kind of community event that should have been happening all along. I brought Buck to the party, and he was a hit with the neighborhood children. As I stood there watching kids play and neighbors chat, Kevin Morris came over with a beer for me. "Things have really changed around here," he said, surveying the scene. "They have," I agreed. "It is nice to see people actually enjoying living in this neighborhood." "You know, I have been thinking about running for HOA president in the next election, Kevin said. I figure someone needs to make sure we do not end up with another Brenda situation. You would be good at it, I told him. You actually care about the community, not just the rules. That is the idea, Kevin said. Rules are important, but they should serve the people, not the other way around. As the sun set that evening and the fireworks began, I felt a sense of peace that had been missing for a long time. The battle with the HOA had been exhausting and stressful, but it had also brought positive change. Brenda Fairchild was in prison, the HOA was being run fairly, and I could park my truck wherever I wanted without fear of harassment. The legal case had taught me important lessons about property rights, the importance of documentation, and the value of standing up to bullies. It also showed me that sometimes one person fighting back can inspire others and lead to systemic change. Marcus Chen, my attorney, became a friend through the process. We occasionally met for lunch, and he told me about other HOA cases he was handling. Apparently, my case had gotten some attention in the legal community, and he was now representing several other homeowners in disputes with overzealous HOAs. Your case set a good precedent, Marcus told me during one of our lunches. It reminded people that HOAs have limits and that property rights matter. I have cited your case in 3 different lawsuits now. That made me proud. I had not set out to be any kind of test case or legal precedent. I just wanted to park my truck. But if my fight helped other people defend their rights, then all the stress had been worth it. The financial recovery for me was significant as well. Not only did I avoid paying the fines, but the attorney fees award meant I actually came out ahead. I used some of that money to upgrade my equipment and put the rest into savings. My business was thriving, and I was able to hire a 3rd employee by the end of that year. One afternoon in late autumn, I was loading equipment into my truck when a car pulled up, and a woman in her 30s got out. She introduced herself as Rachel and explained that she was thinking about buying a house in Riverside Meadows. I heard about what happened with the HOA, she said. The whole Brenda situation. I wanted to ask you whether you think it is safe to buy here now or if there might be more problems. I thought about her question carefully. The HOA is under new management, and they are doing a good job, I said. But more importantly, you should review the bylaws and understand your property rights before you buy. Do not just assume the HOA will be reasonable. Make sure you know what you are agreeing to, Rachel nodded thoughtfully. That is good advice. It sounds like you learned that the hard way. I did, I admitted. But it worked out in the end. This is actually a great neighborhood, especially now. Just go in with your eyes open. She thanked me and drove off. I hoped she would find a good home, whether in Riverside Meadows or somewhere else. The experience had taught me that HOAs are not inherently bad, but they need good leadership and proper checks on authority. Without that, they can quickly become tools of oppression rather than community improvement. As winter approached and snow began to fall again, I found myself back in the familiar rhythm of pre-dawn plow runs and long days clearing driveways. My truck, the same one that had caused so much controversy, performed flawlessly. The logo on the side was faded from the sun and salt, but I kept it there as a reminder of everything that had happened. One morning in early December, I was plowing a commercial parking lot when I got a call from an unknown number. I answered, expecting it to be a potential customer, but instead, it was a reporter from a local newspaper. Mr. Zimmerman, I am writing a story about HOA reform and accountability. I would love to interview you about your experience with the Riverside Meadows HOA and the subsequent criminal case against Brenda Fairchild. I was hesitant at first. I had moved on from that chapter of my life, and did not particularly want to relive it. But the reporter explained that there was growing interest in HOA reform legislation at the state level, and my story could help illustrate why such reforms were needed. I agreed to the interview, and we met the following week at a coffee shop in Lakewood. The reporter, a young woman named Amanda, asked detailed questions about the timeline of events, the legal case, and the eventual criminal prosecution. She was particularly interested in how the HOA had been able to operate with so little oversight for so long. "It seems like there were no checks on Brenda's authority," Amanda said. "She could issue fines, collect money, and spend it however she wanted, and no one was really watching." "That is exactly right," I said. The other board members were either intimidated by her or just did not care enough to ask questions. And most homeowners were too busy with their own lives to pay attention to HOA finances or governance. It created a perfect situation for someone like Brenda to abuse their power. The article was published a few weeks later on the front page of the local section. It detailed my case, the embezzlement, and the broader issues with HOA accountability. The article generated significant discussion online and in community forums. Several state legislators commented that they were working on HOA reform bills that would require independent audits and greater transparency. I received dozens of emails and messages from people across Colorado and even other states who had similar experiences with their HOAs. Many shared stories of unreasonable fines, arbitrary enforcement, and abuse of power. It was eye-opening to realize how common these problems were. One message that particularly struck me came from a retired veteran named Paul who lived in Aurora. He had been fined $5,000 by his HOA for installing a solar panel system, even though state law explicitly protected the right to install solar panels. The HOA had ignored the law and threatened to foreclose on his house if he did not pay the fine. Paul was considering legal action, but was worried about the cost. I connected Paul with Marcus Chen, and Marcus agreed to take his case. It felt good to be able to help someone else navigate a similar situation. The network of people fighting back against abusive HOAs was growing, and there was strength in numbers. By the time the holidays rolled around, I was ready for a break. I took a week off around Christmas and spent time with family in Wyoming. My parents were proud of how I had handled the HOA situation, though my mother worried that I had taken on too much stress. "You should have just moved," she said over Christmas dinner. "Why put yourself through all that aggravation?" "Because it was my home," I explained. "And I had every right to be there, and to use my property the way it was legally designated. If I had moved, Brenda would have just targeted someone else, and nothing would have changed." My father, a retired carpenter who had dealt with his share of difficult clients and bureaucrats over the years, understood. "Sometimes you have to stand your ground," he said. "Your son did the right thing." When I returned to Lakewood after the holidays, I felt refreshed and ready to tackle the new year. The snow was heavy that January, and business was booming. My employees were working full-time, and we had a waiting list of customers who wanted their driveways plowed. The Riverside Meadows HOA had truly turned around under new leadership. At the annual meeting in January, Kevin Morris was elected HOA president by an overwhelming majority. He immediately instituted new policies focused on transparency and communication. Board meetings were now recorded and made available online. Financial statements were posted quarterly, and any fine over $100 required approval from the full board, not just the president. These reforms made a real difference. Residents felt more engaged and less afraid of arbitrary enforcement. The community Facebook group, which had previously been filled with complaints and arguments, became a place where neighbors shared recommendations and organized social events. I was asked to serve on a newly created oversight committee that would review any complaints about HOA enforcement actions. I hesitated at first, worried about taking on more responsibility, but ultimately agreed. It seemed important to make sure the reform stuck, and that we did not slide back into the old patterns. The committee only had to meet a few times that first year. Most issues were resolved through simple communication, and there were no cases of obvious abuse of power. It was exactly how an HOA should function, quietly and efficiently handling legitimate community needs without drama or harassment. In March, I received notification that Brenda Fairchild had been transferred to a women's correctional facility in Sterling, Colorado, to serve the remainder of her sentence. I did not feel any particular satisfaction from that news. Prison seemed like a harsh outcome for someone who had mainly been a petty tyrant. But she had also stolen from the community and refused to acknowledge any wrongdoing, so perhaps it was fitting. I never heard from Brenda directly, but I did hear through the neighborhood grapevine that her husband had divorced her and moved out of state. Her adult children apparently refused to speak to her. The consequences of her actions had rippled through every aspect of her life. It was a sobering reminder that our choices matter, especially when we are in positions of authority. Brenda could have been a good HOA president. She could have focused on genuinely helping the community and treating residents with respect. Instead, she chose to be a bully and a thief, and she destroyed her own life in the process. As spring arrived and the snow melted, I shifted my business focus back to landscaping. The transition was always a little chaotic, involving equipment changes and scheduling adjustments, but I had gotten better at managing it over the years. My employees were reliable and skilled, which made everything easier. One warm April afternoon, I was mowing a customer's lawn when I noticed an older couple walking by with a for sale sign. They were planting it in the yard of a house 2 doors down from mine. I finished the lawn and drove back to my house, curious about who might be moving. Later that evening, the couple knocked on my door. They introduced themselves as Harold and Martha, and they explained that they were moving to Arizona to be closer to their grandchildren. "We wanted to meet you before we left," Harold said. "We have been following everything that happened with the HOA, and we just wanted to say thank you. Brenda fined us 3 times over the years for things that made no sense. We were too old and tired to fight it, so we just paid. But you fighting back and exposing what she was doing, that meant a lot to us." Martha handed me a card with a handwritten note inside. "We know you probably did not do it for us, but it helped us anyway, so thank you." I was touched by their gesture. "I appreciate you telling me that," I said. "I hope Arizona is wonderful for you both." After they left, I opened the card and read Martha's note. It was a simple message about gratitude and community, but it reminded me why fighting the HOA had been important. It was not just about my truck or my property rights. It was about standing up to injustice and refusing to let bullies win. The house sold quickly to a young family with 2 small children. They moved in during May, and I introduced myself one weekend while they were unpacking. The father, whose name was Jason, mentioned that their real estate agent had told them about the HOA situation. "She said the neighborhood went through some drama, but that it is all resolved now," Jason said. "She actually said it was a good thing because it meant the HOA was being run better than most." "That is true," I said. "The new board is very reasonable. You should not have any problems." Jason glanced at my work trucks parked in the driveway. "Those are nice rigs," he said. "You run a landscaping business. landscaping and snow removal, I confirmed. That is great. We will definitely need help with the yard. The previous owners let it get pretty overgrown. I ended up doing the landscaping work for Jason and his family that summer. It was satisfying to turn their neglected yard into something beautiful. The kids loved playing in the freshly sodded lawn, and Jason told me that his wife was thrilled with how everything turned out. As the months passed, life settled into a comfortable rhythm. The HOA remained stable under Kevin's leadership. My business continued to grow, and the neighborhood felt like a real community for the first time since I had moved there. In August, I received an invitation to speak at a statewide HOA reform conference in Denver. The organizers had read the newspaper article about my case and thought my perspective would be valuable. I was nervous about public speaking, but I agreed to participate. The conference was held at a hotel near the state capitol and drew several hundred attendees, including homeowners, HOA board members, attorneys, and state legislators. I was part of a panel discussion about accountability and enforcement abuses. When it was my turn to speak, I told my story in a straightforward way, focusing on the facts and the lessons I had learned. I emphasized the importance of documentation, knowing your rights, and not being afraid to stand up to injustice. The audience response was positive, and several people approached me afterward to share their own stories or ask for advice. One of the state legislators, a woman named Senator Diane Martinez, told me that my case had helped build momentum for HOA reform legislation. "We are close to passing a bill that would require independent financial audits for all HOAs with more than 50 units," she said. "Cases like yours show why that is so important." Hearing that my experience might lead to actual legislative change felt meaningful. It validated all the stress and expense of the legal battle. If the laws could be improved to protect other homeowners from similar abuses, then something good would come from what had happened. By the time autumn arrived again, bringing the first hints of cooler weather and the promise of another busy snow season, I felt grateful for how everything had turned out. The HOA case was well behind me, but its impact continued to ripple forward in positive ways. I was sitting on my front porch one October evening, watching the sunset and enjoying a beer, when Kevin Morris walked over from his house. "Mind if I join you?" he asked. "Not at all," I said, gesturing to the empty chair beside me. Kevin sat down with a satisfied sigh. "You know, I have been thinking about everything that has happened over the past couple years," he said. "When you first started fighting Brenda, I thought you were crazy. I figured the HOA would crush you with legal fees and fines, but you proved me wrong." "I got lucky," I said. "I had a strong legal case and a good attorney." "It was more than luck," Kevin insisted. "You had courage. Most people would have just paid the fine or moved away. You stood your ground and it made a difference. This neighborhood is better because of what you did." We sat in comfortable silence for a while, watching as the sky turned from orange to purple. Buck wandered out from the house and plopped down between our chairs, content to be near people he trusted. "How is being HOA president treating you?" I asked Kevin. "It is more work than I expected," he admitted, "but it is also rewarding. I like being able to help people instead of hassling them. That is how it should be." "That is exactly how it should be," I agreed. As darkness fell and the stars began to appear, I reflected on the journey that had started with a simple citation on my windshield. It had led to a lawsuit, a trial, criminal prosecution, neighborhood upheaval, and ultimately reform. It had been exhausting and stressful, but also empowering and ultimately worthwhile. My truck sat in the driveway, exactly where it belonged, protected by a property easement that had been validated by a court of law. No one would ever question my right to park there again. And more importantly, no HOA president would ever again be able to abuse their power in Riverside Meadows without facing accountability. That was the real victory. Not just winning my case, but creating lasting change that would benefit the entire community for years to come. Brenda Fairchild had tried to use the HOA as a weapon to control and intimidate people. Instead, her actions had led to reforms that protected homeowners and ensured fair treatment. As I headed inside for the night, with Buck trotting faithfully beside me, I felt a deep sense of contentment. My home was truly mine, free from the threat of arbitrary fines or harassment. My business was thriving, and my community was stronger and more united than it had been in years. The next morning, I woke early to the first significant snowfall of the season. My phone was already buzzing with customer requests for plowing services. I drank my coffee quickly, bundled up in my winter gear, and headed out to the truck. Buck watched from the window, his tail wagging as I started the engine. The truck roared to life, its plow blade gleaming with fresh snow. As I backed out of the driveway, that same driveway that had caused so much controversy, I smiled. This was my life, my business, my home. And no HOA could ever take that away from me again. The streets of Lakewood were covered in fresh powder, and the city was just beginning to wake up. I had a long day of work ahead, but I was ready for it. Every driveway I cleared, every parking lot I plowed was a reminder that I had fought for my right to do this work and won. The sun rose over the mountains to the east, painting the snow-covered landscape in shades of gold and pink. It was going to be a good day. More importantly, it was going to be a good life, built on the foundation of standing up for what was right, even when it was difficult, and that made all the difference.